Good morning, everyone, and thank you for joining us. My name is Amanda Schaub, and I'm an Executive Director of the Building Owners and Managers Association of Pittsburgh, also known as BOMA Pittsburgh, and I will be moderating today's discussion. If BOMA Pittsburgh is new to you, I'm going to give you a brief introduction. Since 1919, BOMA Pittsburgh has been helping building owners and managers maintain safe, efficient properties in Western PA, and we do this through state and local advocacy, fostering professional connection through networking events, serving in our local community, and training the next generation of commercial real estate leaders. BOMA Pittsburgh is hosting this webinar in conjunction with the Insurance Club of Pittsburgh, and they are also a nonprofit social networking organization founded in 1926, and their goal is to connect insurance industry professionals through networking and education. Club members consist of agents, brokers, company reps, claim adjusters, restoration companies, finance companies, and other individuals related to the industry. They are also known for organizing and hosting one of the largest insurance functions in the country, I-Day, aka Insurance Day. We have Alyssa DiPofi, who is a board member for the organization and also a BOMA Pittsburgh member, joining us this morning.
Hi, everyone. My name's Alyssa DiPofi. I work for FireDex of Pittsburgh. I am the manager of marketing and client relations. FireDex is an insurance-based restoration company. We provide full service repairs and mitigation for residential and commercial buildings in southwestern Pennsylvania. Our company has been a member of BOMA for many years. Our company has also been a member of the Insurance Club for many years. I have been a member for 4 years and served on the board now for coming up on 3 years. I was super excited to work with BOMA Pittsburgh to provide insightful information to our Insurance Club members during the COVID-19 pandemic. So thank you all for joining us today.
Thank you, Alyssa. We also have Ron Jones with Jackson Kelly, who helped set up some of our panelists for today.
First and foremost, thank you, Amanda, for having us. My name is Ron Jones. I am a member here at Jackson Kelly in Pittsburgh. We're a full service law firm. So what that basically means is we do pretty much anything that you can think of legally, tax, employment, litigation. I work in commercial litigation, general litigation. And yeah, again, thanks for having me.
Thanks for next, I'm going to let our panelists introduce themselves. Michael, do you want to go ahead and get started?
Sure. Thank you, Amanda. My name is Michael Leahey. I'm also with the law firm of Jackson Kelly. I am the assistant managing member and managing member of our Pittsburgh office, and I apologize, my phone's going off in the background here. It shows we're busy and lots of people have questions, but I run our litigation practice here in the Pittsburgh office. And I'll primarily be discussing and addressing questions involving litigation-related issues arising out of some of the state and federal orders, and the issues that building owners and managers will have as they are implementing COVID policies, both for the safety of their people and their guests in their buildings, as well as some of the other issues that will surround that. So I appreciate being invited to the panel, and hopefully we can provide some good information for everybody today.
Great, thank you. Next, we're going to move on to Justin.
Hi, and thanks for having me. I'm Justin Dorman. I'm our National Product Manager for Burns & Wilcox, and I focus on workers' compensation. I'm actually based out of Charleston, South Carolina. And today I'll be speaking to you as the insurance panelist, focusing on workers' comp, but hopefully touching on some other lines of business to help you better navigate and understand what's happening right now. So thanks for having me.
Great, thank you. And then finally, Jason.
You know, Ron had spoken with Mike and me about, about this panel and everything, and obviously he needed a lot of reinforcements. So I'm also with Jackson Kelly. I'm a corporate transactional attorney, so I bring a little bit different perspective than, kind of the litigation side of things. So we very regularly kind of act as business advisors for our clients. I'm also the chair of our tech and data practice group here, which in a lot of ways, just kind of underlines that kind of business advisory, corporate transactional work in the tech space, which is kind of interesting in the context of real estate and where commercial real estate's going and how that's all going to function, obviously, in the current context and then moving forward as well. But so obviously we appreciate the opportunity to be with you all today, and very interested to kind of discuss these kind of pretty cutting edge kind of topics, and I'm sure learn a lot too. So thank you.
Great, thank you. Thank you all so much for joining us for this discussion to kind of, educate both BOMA Pittsburgh and the Insurance Club on some hot topics and relevant questions. So for the group that's on the attendees, we are going to start with some prepared questions, but please feel free to use the Q&A feature at the bottom of your screen to ask follow-up questions that I'll monitor while our panelists are answering those questions. And then we did leave 15 minutes at the end for any additional questions that you'll have that we may not have addressed with our prepared questions. So I'm going to start with Justin. Our first question: with difficulty determining the precise moment the virus is transmitted, what are some key factors for deciding should an employee contract COVID-19 if they will receive workers' comp?
So key factors if employee can receive work comp can be pretty confusing, and especially if you're on the business owner side and not the insurance side. Hopefully we can help you kind of navigate and shed some light on that for you. So right now, I'll start out with talking about presumption laws. So I think a dozen states or more have passed presumption laws. And as far as correct me if I'm wrong, but Pennsylvania's, they're still in the, it's still in the House pending. But these presumption laws will help certain employees in certain industries collect work comp benefits, kind of passing that red tape and letting them get the benefits they need so they can get healthy and get back to work. Just setting expectations. It's going to be very difficult in Pennsylvania to gain those work comp benefits just because it's so difficult for a disease that is so contagious and can be contracted anywhere to prove it came from work. So if I was a business owner, I would just make sure that you're keeping up to date with all the local regulations that are being passed, the presumption laws that are being passed, to see if it's going to affect your business or not, and whether or not your employees may be covered.
Okay. And then we're going to ask our next question that we have for you. What liability risk does a company endure should a client or customer contract the virus while either with an employee of your company or within your building?
Yeah, so what kind of liability will exist? So starting off on the work comp side, there's not much liability there, as we discussed earlier. Obviously, customers aren't employees, so you don't have to worry about the work comp side for that. And letting your employees come back, it's the same difficulty proving that, if that employee contracted COVID at work, whether or not they really contracted at work or somewhere else. So from the work comp side, there's little liability. Now you may see it on other lines of business, such as general liability. We have seen claims come in on the general liability side where guests, clients, patrons have contracted COVID and they have filed suit against a local business saying it came from them. We also recently have seen on the professional liability side, it was an employment practices liability, and that's where you sue your employer for certain claims. And this one was an employer required an employee to come back because they were deemed essential, but an employee in a very similar position was allowed to work from home. So the one who had to come back and was comfortable being back in the office filed suit on their employer's EPO policy. So I'm sure we'll start seeing claims come from other lines of insurance, even environmental insurance, even though most environmental policies have a disease exclusion. I'm sure we'll still see claims come about from that and other lines of business as well. So we're still very much in the early days as far as insurance is concerned, because we don't have a lot of data yet. So we're just every day, we're just trying to keep on top of what we're seeing out there. And from a non kind of work comp or really insurance, and kind of piggyback off of what Michael said, it's just keeping up to date with laws, regulations, CDC recommendations, OSHA recommendations, the EEOC. Their website's really great. They have a lot of good FAQs there. And especially when it comes to the ADA, the Americans with Disability Act. And I think Michael and Jason are going to talk about that later. So I won't dive into that, but confidentiality is going to be huge because, you know, you can't divulge the name of an employee who has COVID. So there are workarounds and things you can do, but, you know, it's just staying on top of this as a business owner and making sure that you're doing everything to keep your employees safe, your guests safe, and yourself, you know, and your business safe.
So for Michael or Jason, what, if any, are the differences in liabilities between employees and guests at your business? Can they be different, and should they be?
Sure, I'll take that one. The short answer is they are different. As an employer, you have a heightened duty to protect the health and safety of your employees. And typically those responsibilities that you have as an employer are set out both through the Occupational Safety and Health Act, or OSHA, as well as through various common law. As an employer, you owe a heightened duty to protect the health and safety of your employees. And so what we're all kind of used to in this world are things like asbestos, lead paint, and other types of environmental hazards. I think the safest approach for employers is to treat COVID similarly to the way we would treat other environmental hazards within our workspaces, and ensure that our policies and procedures are there to protect our employees. As a premises owner, the duty is a little bit different and depends upon the person coming into your premises. And under Pennsylvania law, there are a couple different statuses that entrants onto land can have. They can either be trespassers, they can be licensees, which is essentially a social guest, or they can be business invitees. And so in the context of owning a business, the majority of the people that you have coming into your business are going to be business invitees. That is the status of guests that you owe the highest duty to. But that duty does not rise to the same level as it does to an employee. So for example, for a business invitee, you have a duty to protect them against hazards that you as the owner of the premises would be aware of, but that the guest coming onto the premises may not be aware of. So back to kind of traditional hazards, asbestos would be one that if you know that there's asbestos in the property and you have a contractor coming in to perform work, you would have an obligation to let them know about that. But the ultimate duty to protect those people falls to the employers of those contractors. So moving that over into the new COVID world that we're dealing with, let's say you own a grocery store and you have people coming in. Those are business invitees. You do have certain duties to protect them, but those duties are not absolute. So you want to make sure that you are certainly complying with any state, local, and federal guidelines that have been issued relative to people coming into sites. So in Pennsylvania, the mask order is one. You certainly want to be sure that you are doing complying with those laws in order to protect the health and safety of people coming into your facility. But those duties are not going to rise to the level of OSHA and the issues of workers' compensation that you have to deal with relative to your own employees. So the short answer to that is you want to ensure that you are complying with any regulations, statutes, local ordinances relative to allowing invitees into your premises that have been enacted to combat COVID. But you don't need to worry about protecting those invitees from the world.
Great, thank you. As an employer, can your policies be more or less restrictive than state and local orders? And is this different for businesses in relation to their guests? Can you specifically address quarantine requirements in PA for employees?
What I'll say first of all is that, Mike's really smart. So he already really covered this question too. But so I, rather than, kind of revisiting, the excellent explanation that he already gave us, I think, and I know we have kind of a final topic that Justin just referenced in the ADA kind of issues that Mike's going to cover here in a minute. But what I'll say is maybe more from a practical standpoint, obviously concerning these issues would be for the owner of a commercial property or property manager. I think what might be a very useful exercise and something that we've discussed already with our clients in the current situation is to take a look at what your leases actually say. So, you're going to have various provisions in there, for example, and Justin just references compliance with laws provisions, other kind of provisions that say, you need to keep up to date and make sure that you're compliant with any existing state or federal law, right? So as a building owner or property manager, I think it's important to keep an eye on that and what exactly do those leases say, because you need to make sure that your tenants are in compliance. For example, and I'm not there right now, I'm at my house, but in our building where our firm is, the property manager has been very proactive in reaching out to us and making sure that everybody's on the same page about what the current regulations are that are in place. There's a lot at play there, right? I mean, we're in Pennsylvania, so we have the governor of Pennsylvania with certain orders that are in place. Then we have our Allegheny County is the county where we're located. The county executive has recently been issuing some different directives as well. I think it's something that's important to, first of all, know what's in your lease, what are your rights and obligations under the lease. Not only as a property manager, but maybe as a tenant too. And then as that property manager or building owner, being proactive about reaching out to tenants and making sure that they're being compliant. And to the extent that it's helpful, maybe even sending out some type of information, just updating people on what those directives are to help them along the way. Now, there are other reasons that you should be looking at your leases right now, obviously, that are kind of apart from what the topics I understand are for today's discussion. But, financially, obviously, what are we doing about defaults, and what are we doing, kind of up the chain of, well, as an owner, what's the situation with my lender? Because that's how I get paid rent, and then that's how I pay my lender, right? And so if I can get a forbearance, maybe there's some type of moratorium in place. This is different in different jurisdictions, obviously. So there are other reasons to kind of take a look specifically at your leases, but yeah, with regard to these particular topics, I think that that's very important. First of all, to understand what your rights and obligations are, and then to be proactive. Additionally, and this, I feel like we say this to clients all the time, and it's normally under, not the best circumstances, but maybe it's an opportunity to revisit exactly what is written in that template lease agreement, and should we adjust that in some way for the future? Do we need to tighten up some of those provisions? Because, if you don't have the language in there that strictly says that, you have certain rights, or that it's a default if somebody, for example, is permitting people into their store and not requiring the masks, for example, and they're a tenant of yours in your building. What repercussions does that have for your building? That's not good, and so you may end up with being in some type of negative situation yourself. So that may be a good time to revisit, the language that you actually have in your lease agreement and what your approach to that is going to be in the future. So like I said, that's a little bit off topic, but it's, I think relevant to what we're talking about, and more from the business kind of side. Practically speaking, something that I think I would think is probably on the minds of some folks out there, and something that we'd be happy to explore more. But I know we've been actively talking with our clients about.
Yes, for sure. We did mention kind of in prep for this call about force majeure and some lease language. So for those that are attending, if you have questions related to that, please feel free at the end to ask those questions. This group would definitely be able to address. And then we did get a Q&A, a question that came through that I think goes along with this question the best. Someone's gotten questions from several clients. If your business is required to do screenings on employees, who can perform the screening? So that is something I heard as well. Is, does this need to be a medical professional? Is that information stored? I think there's a lot of, businesses in general, and then particularly with BOMA, building owners and managers, they aren't HIPAA, experts. So I think this is a great question on a lot of people's minds.
Sure. So this question is definitely a hot topic right now. In terms of screenings, there's really a couple different degrees of what I would call a screening. One thing, for example, that our law firm is doing is sending out a questionnaire to all of our employees to fill out every morning that they come into the office. That allows us as the owners and as the employers to determine if one of the people that was at the office during any given time period were to be diagnosed with COVID. We would then be able to determine who else was in the office that day, be able to contact trace that person throughout the day and throughout the days that they were there, and notify other people in terms of a self-quarantine. Those screenings can get more involved to the extent that people are doing temperature checks as they come in, as employees come into the office, or as people come into a facility. And the guidance that we've gotten at this point is those temperature checks are not medical procedures, and so can be performed by anyone from the building security if it's done at a building level, a receptionist if it's done at an office level. And Amanda, you brought up a good point relative to HIPAA. You're correct that by collecting this information, we are not, and building owners are not, medical professionals. And so that information does not fall within the confines of HIPAA. However, we have an entire HIPAA privacy group here at the firm, and they always like to beat me over the head and remind me about all the potential pitfalls. The one thing I will kind of say to everybody is you can be a quasi-HIPAA entity. So for example, if you administer your own health plan, you may have some HIPAA-related privacy information to the extent you are getting and processing claims data for your employees. The one thing that I would simply say to be careful of is making sure you have separate baskets to put the different jobs you do, making sure to keep your screening information out of and away from your handling of claims information, which may place you in a HIPAA role. But we believe at our law firm that being proactive in terms of screenings, contact tracing, things like that, really put you in a good position to protect the health and safety of your employees. So it's something that we think is a good thing. You need to be careful not to cross that line, though, between screenings to do your best to figure out who may have COVID, who may be at risk, versus moving yourself kind of across the line into more true healthcare related issues that may put you afoul of some other statutes such as HIPAA or the American with Disabilities Act and other things. So not an absolute answer, but kind of the best one we have.
Great, thank you. Next, we're going to move back to Justin. Has there been a notable increase in liability and workman comps claims since the inception of COVID-19 leading up until now, and where employees are being called back to work?
When this first started, we had estimates all across the board. Some states were saying they're going to have $20 billion of COVID, just because we've never had anything like this. I think 9/11 was kind of the closest we had to a large scale work comp set of claims, but it was still in very few cities. So we're having this on a national scale. Everything is kind of an estimate. So right now, the initial numbers that are coming through from March to June are much lower than expected. So what we're seeing is a lot of people are treating this similar to the flu, where they take some sick time, they take a week off or so, and then they're back at work. So very small percentage are actually filing work comp claims. It looks right now the average claim is around $5,000, and that's for outpatient. We're not taking into account the severe cases that are kind of outliers on this. So, just medicine, doctor visits and stuff like that. So it's much lower than expected right now. Some of the main industries that are being hit with claims are healthcare, of course, that they're leading the way. Meat packing, you've probably heard of some of the big meat packing plants having to shut down because they worked in such close quarters. And then also farms with H-2A migrant employees because they share housing on the farm land usually, and they're in close quarters. So some of those industries have been impacted more than others. And we're also seeing less claims across the board in all lines of business, in all classes of business, because people are working from home. So there's a lot of thinking that even if the COVID claims get a little worse, it's still going to kind of balance out in the work comp world because we're not having the usual claims we see in a lot of other classes of business. And then also, we don't know the long-term cost of a lot of these COVID claims. So every day there's more articles coming out saying there may be respiratory long-term effects, brain damage long-term effects, and then also employees filing for mental health coverage because they've been in isolation so long and it's really affecting them. Maybe they have depression or something like that. So there's a lot of long-term effects that we're still waiting to see. And it could take a while to kind of see the end point on this. A lot of carriers don't have to report claims data for up to 6 months or so. So in the next few months, we'll start seeing some more hard data. And then the next year or so, we'll really be able to see how COVID really impacted workers' compensation. I know a lot of you for business owners are wondering if rates are going to go up. So right now in the industry, we don't expect rates in 2021 to increase. We still see a slight decrease. They've been decreasing for the past 5 years or so. We've had the best, most historical profitable work comp time frame we've ever seen in the modern work comp world. So we're in a great place, even if the COVID claims do end up being a little higher than expected. If rates do increase though, in the next 12 to 24 months, it's not necessarily going to be due to COVID. The claims itself, it's going to be due to our economy. So payrolls are lower, makes premiums lower. There's less return on investment for our carriers, which means that's they make most of their money on their investments. So a lot of insurance carriers are going to have to look at their book and make adjustments to their appetite, which could lead to a contraction in the marketplace in the next few years. So yes, rates may go up, but there's a lot of other causes besides COVID claims themselves.
And then this is a big topic, is kind of what we hit on a little bit before about the ADA and the mask. And we got basically questions almost exactly of what we talked about previously, Michael and Jason. When it comes to the mask order, how can businesses manage this? Can a business or a building deny entry? And specifically to, ADA, are there questions that you're allowed to ask specifically if someone says it's due to a medical issue?
Sure. So this is really kind of where the rubber hits the road. And for those that are in Pennsylvania, we've already seen lawsuits filed over this. There was a lawsuit filed against the parent company for Sandcastle, Kennywood, and Idlewild Park and Ligonier. And that lawsuit involved the parent company's policy that entrants into its parks had to wear masks at all times. There was a mother and child. The mother said that she had anxiety disorders and the child had autism and couldn't wear masks. And they were, at least based on the allegations within the lawsuit, forcibly escorted out of the property. And as a result of that interaction, the child developed hives and had some significant mental issues. And so, we've talked thus far about ensuring that we're complying with the orders. But the Americans with Disabilities Act does require accommodations for disabilities. The problem with a lot of the disabilities that would affect a person from wearing masks are they're not visible and readily ascertainable as a person walks into your facility. So among the physical conditions that are most likely to affect somebody wearing a mask are respiratory insufficiency, the inability to breathe in and breathe out with enough force to overcome the restriction that the mask places on them. And then we have a host of psychological issues such as claustrophobia, anxiety, and as the weather's getting hotter outside, a lot of these things are exacerbated because wearing a mask, you do rebreathe at least a certain amount of CO2, which if you're already kind of in a panic situation, and we know people with anxiety right now have heightened anxiety simply because of the condition and what's going on in the world, there's some real concern that that could cause some negative outcomes. So how do you balance these two things? And the question that I get as a litigator more often is, how don't we get sued for whatever we do? And the answer to that is, there's no good answer to that. But really it is have policies and procedures that are flexible enough that you can take these cases on a case-by-case basis. In an ideal world, and everybody's business is different, in an ideal world, if somebody is unable to wear a mask in your facility, you have some other process or procedure by which you can still service that person without having them access your site. So for example, Pennsylvania liquor stores have curbside delivery service. So you can call, order your wine and liquor, and it will be brought out to the front door to you. And so if to the extent you have a business that would allow for something similar to that, I think that that is the best potential option. And there are also differences between whether or not your business provides critical services or non-critical services. So if you own a pharmacy or a grocery store, and we've seen, I'm not sure if any of these have made it to actual lawsuits yet, but we've seen claims being made against Giant Eagle for their mask policy. You want to do your best to treat people with respect. And it kind of goes back to what your mother told you when you were kids. If you just treat people nicely, everything will be okay. We want to have policies that encourage mask use. That is compliance with the law. But recognizing the ADA, we need to make exceptions for that. And that doesn't have to be you allowing people into your premises without a mask, but you have to have some accommodation for those people. So at Kennywood, it's difficult to have an accommodation. You can't bring the ride outside the park to them. And to the extent that a child has autism and can't wear a mask, we need to figure out some way to accommodate that medical condition without endangering the health and safety of the rest of your employees and the other patrons of your park. So in each situation, that's going to be a little bit different. And, as we all know, there are going to be people who say, I have a condition that I can't wear this mask simply because they don't want to wear the mask. It's really difficult to get into a fight with somebody at the doorstep to Giant Eagle where you're saying, no, you don't have anxiety. Yes, I do have anxiety. You are in a no-win position at that point. So this isn't necessarily legal advice as much as it is practical advice. Take the person aside into a quiet location where it's not done in front of everybody else and have a conversation. How can I accommodate what you need without putting my employees and my other patrons at risk? Most people are very willing to have that conversation and maybe say, hey, I need eggs, milk, and bread. Can you get it and bring it out to me? See what you may be able to do. The other thing I will say, and this is an unfortunate occurrence which we have started to see in the litigation world. For those of you who own businesses and own premises, you know this. There are what I have referred to as the ADA trolls. There are law firms that go out there with a test plaintiff in a wheelchair and they find the locations that are not ADA compliant simply so that they can then make a claim because one of the provisions of the ADA is you get your attorney's fees paid for. So they will go out to a gas station that has a restroom that is not ADA compliant. They will file a suit with this test plaintiff. The actual damages available to the test plaintiff are probably nominal. What is the true damage to not being able to use the restroom? Again, I'm not saying that it's not an issue, but the monetary damages are not that significant. The problem is that attorney may rack up $50 or $60 or $100,000 in legal fees advancing that claim that you may become liable for. So we know these claims have been out there for quite some time. I firmly believe that business owners and premises owners will start to see these ADA claims relative to mask policies. And the best way to avoid them, not that you can absolutely avoid them, is to have a flexible enough policy that allows you to make accommodations and then make those accommodations in a way where you are doing your best to balance the two outcomes, the wearing of the mask and protecting health and safety, and the accommodation of somebody's medical concerns. And if you do that, you're putting yourself in the best position, but you're not completely insulated.
Great. And then just as a follow-up of the question that we got earlier that tied in, so specific to buildings, and Jason hit on this earlier about you should really look at your leases and what that language says. And particularly with the climate, I don't think buildings really want to be like denying access to a property if people want to be using it, because it's like Jason said, this is an interesting time for commercial real estate. But, can a building deny a tenant access? Again, if it is an ADA that's been confirmed, they're just like choosing not to do it. or what is the best way to address that issue or concern?
Sure. Yeah. And I mean, I think, Mike really kind of answered a lot of that. But what I would say in addition are a couple things. Number one, make sure that, for purposes of the eventual potential lawsuit, right? And also just for purposes of running your business right now, and managing the property, you want to make sure that you have as much actually written down as possible to create, a body of kind of evidentiary documentation that says, for example, that sign that's on the front door that says you must wear a mask to enter. Making sure that you are, you put a memo together periodically, like I talked about before, periodically that you are issuing out to all of the tenants in your building, for example, maybe with updates about whatever the latest directive might be from, your local or state government. Making sure that, you have those policies, and also thinking through what are, and this is to Mike's point, what are the specific accommodations that you can reasonably provide to enable that tenant to, gain whatever access they need or whatever, to exercise their rights with regard to their tenancy in your building. Maybe that is, all right, well, what you actually are looking for is there are certain files that you need, and there are 15 people in your office. Okay, well, can one of the other people who can wear a mask come in and pick up those files and bring them out, to the person who's not able to wear the mask? Is there, what are the items that you specifically, need access to? Because that's totally understandable. I mean, you need to continue to run your business, and, a lot of people anymore are fairly paperless, right? But there are still sometimes some things that are maybe in the premises that you need. I think that's, putting together that documentation helps you then later to have something to point to. So I think that's helpful. Another point that we didn't, and we had talked about before, but just to quickly touch on, that's kind of related to that, is the idea of waivers. So you might have, and that has to do more with, invitee type guest situation into a store. But part of what happens there is whenever you're in so just quickly, certain businesses would be the type of business that you traditionally would expect to sign a waiver to enter, right? So like a gym, for example. Anytime you join a gym, even pre-COVID, you probably sign a waiver that says, I understand that it can potentially be dangerous for me to come in here and exercise, and there are weights and they can drop on my toe, kind of thing, right? So those waivers are something that traditionally would always be there anyway. So for certain businesses, you could update that waiver to include an acknowledgement with regard to COVID, and an acknowledgement to Mike's earlier and Justin's earlier point that this is not something that we can see. It's not readily ascertainable where COVID is, right? And so you would want to update the language in that waiver document, but that would be in specific types of businesses. You could do that. Now you also could do that as a building owner, premises, manager. Okay, well, we just, to have in our records, we want everybody who's going to come into this building. Now, it depends how big your building is, right? I mean, how many people are we talking about, right? But that could be an approach. That you say, okay, well, anybody who's going to continue to come in here while there are local and state governmental directives in place, I need them to sign that, right? Or the person who is in charge of that office for a specific tenant needs to sign and acknowledge, okay, anybody who comes in here, it's at your own risk, kind of thing. That does not 100% absolve anybody, and it certainly doesn't protect against being sued, because you can be sued by anybody for anything, anytime, right? But what that does do is it provides additional evidentiary proof that you were trying to do everything you reasonably could to make sure people were aware of dangers that were out there, right? So yeah, I mean, I think that would be, so, and those waivers again would help that. So I don't know that that directly answers the question because Mike pretty much already answered the question, but yeah, I think those are some other things just to keep in mind from a business standpoint.
So for the attendees on the call, we're going to leave this part open for any additional questions that you might have. While those kind of wait to come in, waivers have definitely been a conversation. So just to follow up on the waiver question, is there anything that like can't be asked or can't be listed on that waiver that you guys could think of that's like an absolute no, or like somewhere that people could find like a sample template for specifically in PA, if that's even an option?
You know, from a enforceability standpoint, a lot of times courts will look at those waivers as being, you know, what we would call like a contract of adhesion or something where you say, okay, well, this person just kind of signed this waiver. They didn't really understand what it exactly meant, you know, that kind of stuff. So there's a question of how enforceable the waiver is going to be. Again, at this, and you know, this person really badly wanted to go in and use this facility, and this was the only way to do it, you know, that kind of thing. That's going to depend on a couple different things. You know, how essential is the service? You know, how essential is it to, you know, for me to go in here and access this particular service? If like in the example of a gym, I mean, it's not, you know, it's not life and death in most cases, whether you go to the gym or not, right? But in other facilities, that probably wouldn't fly. So again, the reason that I bring that up is you're just trying to build what you can to memorialize what you can about what the situation is and that you have provided warnings, basically. And so you are trying to be as reasonable as you can in approaching the situation to say, okay, this person clearly had some understanding that there were risks involved in accessing my location. Whenever something bad happened to them, they at least knew that a little bit. And then that later is something that you can put into evidence, you know, in potential litigation in the future.
The one thing that I would add to that as well, for anybody who's considering doing waivers, the one place where waivers absolutely are not enforceable is with your own employees. So at least in Pennsylvania, there's an affirmative defense to lawsuits called assumption of the risk, that you assume the risk. So for example, in the gym situation, you assume the risk of working out with weights, and the fact that you drop them across your neck, that's a risk you assumed, which is why I don't go to the gym. But the other half of that argument is you cannot ask your employees to waive risk attendant to their job, and you can't assert assumption of the risk as a defense in an employment-related injury case. So because you can't ask your employees to assume the risks of their job, if you run Giant Eagle, you can't have all your cashiers sign a waiver that says, hey, if I get COVID because I'm working here, I don't have any right to workers' compensation or to sue you. Those would be deemed to be unenforceable.
We do have, BOMA has some members that manage residential properties. So is there any difference in, I know that whenever you, like, for example, I've gotten notifications at the building that we're at that there's like a presumed case, and it obviously doesn't mention anyone's name. Is there anything different when it comes to notifying, at a residential location? Typically it's a high rise that are our members, and then also enforcing a mask policy in those common areas as opposed to a business or a building.
So kind of going back to Jason's comments, I think it's really important for the building owners to look at their leases. Typically the common areas and control of the common areas are reserved to the building owner. And so because of that, the building owner can enforce policies. They can't tell somebody they have to wear a mask inside their own office space or inside their own residence. But because under most lease agreements, they do control the common areas, they could certainly say that, masks must be worn. Again, with a recognition towards ADA and accommodation policies, because with a residential building, you also have issues of barring someone from their residence. So it's a little bit trickier there. But again, I think when you look to the lease language, as Jason said, you can be sued for anything by anyone at any time. But you really want to ground yourself within your lease language. And if you have the right to make policies, so for example, a lot of buildings that have common areas may have quiet hours within certain periods of time because they don't want other tenants being bothered. The same ability that you have to enforce quiet hours would allow you to enforce a mask policy, and maybe even more so the mask policy, because again, that is simply complying with state and local orders. But you know, you're really going to want to look to that. And as Jason said, this is a great time to look to your policies and your leases, because typically the times that we all look at those and dust them off is when a lawsuit gets filed, a claim gets made, and it presents a really good opportunity to dust those off and think, we've never really thought about a global pandemic before in terms of writing this residential lease. Maybe we now need to take a look at this and figure out if we need to reserve to ourselves some additional authority so that we don't end up in this situation in the future.
Great. And then we did have another question come in. Can an employer restrict vacation travel for employees to avoid hotspots and potential quarantine? And or this is like an add-on to their question, because I got this and we discussed previously, can you require, you know, quarantine, even though our state's suggesting it, it's not currently required. So can an employer do that?
So really good question. One that we are currently struggling with at our law firm with our internal policy right now. As I said, I'm the assistant managing member of the law firm, and this has become a true hot button issue. What I will say is vacation time is an employee benefit. So it's governed by ERISA. You cannot restrict a person from taking their accumulated paid time off. That would likely violate ERISA and not only that, but cause your employees to hate you more than they may already. That being said, can you restrict where they travel? If they're not on company time, clearly taking vacation time, I think there's some real issues with, can you restrict where they travel? I think the safe answer to that is no. However, can you put into place policies and procedures for when they return from travel to a COVID hotspot? So somebody wants to go to New York City, or, you know, in this day and age, Florida, and stand shoulder to shoulder with people at a bar in Florida. Can you then force that person to quarantine upon return? I think the answer to that is yes, because again, you are now in the position of having to protect the health and welfare of your employees. But can you do that without pay? Do you have to make accommodations for people who really have in-office functions that can't work remotely? All of those are less certain. And the other big thing I'll say is Jason brought up multiple times, documentation is key. And making these decisions before people travel is important, because you can't have people who are currently sitting on a beach in Florida and you then hit them with an email while they're gone. Hey, by the way, when you come back, you've got to self-quarantine for 14 days. Depending on their job, their position, all that kind of stuff, that may not be possible, or may not be, you know, if they had known that before they went, they may have made a different decision. So advance notice to employees and, you know, just kind of working through those issues, I think, is important. But certainly the one thing that I would say is an absolute is you cannot restrict a person's use of vacation time unless you have a policy and procedure already kind of on the books. So, you know, a lot of times seasonal businesses may restrict people from taking time off during certain times because that's their busy season. You know, if you run an accounting firm, letting people off at the beginning of April or, you know, in this year, the beginning of July, and if you haven't filed your taxes, you should do that today. Today is the new deadline. But if you have a policy like that already, you can certainly enforce that policy because they knew that when they signed on. But to have a policy that wouldn't allow them to access that benefit would be problematic.
So it took us right to 11 o'clock. I don't see any questions trickling in. So I want to thank the panelists. I thought this was a great conversation. To everyone that has been in attendance, this has been recorded, so it will be shared hopefully within the next week on BOMA's YouTube channel, so you can reference back to it. And then I'd be happy to connect you with any of the panelists or Alyssa and Ron if you guys have additional questions to follow. But thank everyone so much for joining us.